Hey guys, welcome to Streak Initiative, and again this week we are covering polity related questions which are important for your prelims themes. And again, I would like to emphasize here, use these videos as a break between your preparation so that you can just revise some of the important current affairs related themes that have been covered over the span of last 1 year. So today, the first question that we're going to talk about is consolidated sinking fund. Now, we've usually heard about a lot of funds like that. Like we've got Consolidated Fund of India, we've got the public accounts, and now this particular piece of fund has been in news. So yeah, these kind of topics are always important. They have been coming in previous year question papers also. So since this topic was there in your current affairs, so I picked up this particular fund. Now it's just basically whether you know what this fund is about is all this question about. So there are three statements given with respect to this fund, which is the fund should be maintained outside the consolidated fund of states and the public account. Second, it should not be used for any other purpose except for redemption of loans. And third, that it is administered by Department of Economic Affairs and respective state treasury. And you have to identify the correct statement here. So, see, the Consolidated Fund of India, of the center and the states, these all are under the constitutional provisions in a way. So you usually read about them in the constitution also. When we're talking about consolidated sinking fund, it's not something that has been created by your parliamentary laws or something like that. It was actually in fact made by RBI. So if you've read basic idea about this particular fund, the first thing that you read is that it was set up in 1999 and 2000. So it's something much more recent than other funds we are talking about, say public accounts or something like that. So it's a very recent initiative of the RBI, which was actually made so that in case of any emergency, we need to keep certain money as reserve for redemption of the market loans which state governments have taken. So it was initially 11th state had made this particular fund. Then your 12th Finance Commission had recommended that all the states should take this particular initiative, and they should contribute at least 1 to 3% of their loans that they have taken to this particular fund, so that it can act as a buffer for this particular fund. And this particular fund is actually managed by the center account section of RBI, Nagpur, right? So as soon as you know this particular statement, I think the third statement can easily be put to wrong. Like it's not under the Economic Affairs Department, it's under RBI. So we are just left with A and B as an option. Now, second statement here is yes, it is not used for any other purpose. It's just redemption on loans. Basically, it provides a reserve to take care of any emergency situation where we need to make sure that the loans are repaid. That kind of money is used from this fund. So, statement 2 is correct. So, automatically we get B as the answer. Again, with respect to this question, you can take out few minutes, revise your other funds, Consolidated Fund of India, the public accounts, what's the difference, and which, or what you can do is you can revise that financial articles like the money bill. You can revise the financial bill A category, B category, all these categories you can revise. Let's move on to the next question, and here we are going to talk about the appointment of the Chief Minister. Now, the first statement here is that the Constitution does not require that a person must prove his majority in the Legislative Assembly before he is appointed as a Chief Minister. And the second statement is that the term of Chief Minister is not fixed and he holds the office during the pleasure of the Governor. And you have to identify the correct statement here. Now, see, if you catch here the issue in this particular the issue usually when we talk about like the difference between, say, how does a chief minister is appointed versus how does a prime minister is appointed, that kind of clearance should be there. Like, even if you're talking about chief minister, be careful about how the chief minister of, say, Delhi is appointed. there's a slight difference between Delhi and other chief ministers of the state. So these kind of intricate differences, say between prime minister or Delhi chief minister or other states chief minister, that should be very much clear to you. So here we are talking about general chief minister with respect to our states. And see, the answer of the statement is C actually. So it's a very common thing, that any kind of appointment is made as long as the person enjoys the majority in the legislature, the chief minister will hold the position. So I think statement 2 is pretty easy to understand. And if we're talking about the appointment as such, then there is this article 164 which deals with the appointment of chief minister, and it says that the position is appointed by the governor, and how is not mentioned. I think it's not even mentioned in case of prime minister, but there are certain set of parliamentary conventions which have been followed up till now. So whichever party has the majority or can prove the majority in the legislature, the leader of that party is usually appointed as the chief minister, and that is what happens in the state. Again, governor can do that. In case, again, if there is no majority here, then the governor can appoint through his discretion. But again, there's no complete discretion here. Like there's a priority list followed here. Like the coalition party, the leader of a coalition party which has the majority. So one by one, post election, before elections, those kind of coalitions also. So there's a list through which governor can appoint. Again, basically it's revolving around the majority here. So both the statements are correct here, A and B. So answer of this statement is C. Again, one thing, like I told you, make a note of how Delhi chief minister, like is that person appointed by governor or not. So that is one thing that you should be careful about. Let's move on to the next question. The language question. This is dealing with your 8th schedule. I think I've told you before also, we've covered 5th schedule yesterday, 6th schedule. So again, I'm telling you, schedules are very important, and they have been coming in your previous year question paper. Recently, I think there was this EPFO paper, and a question from 8th schedule was directly asked here, like which language is not a part of the 8th schedule. So again, I picked up this question just for a revisory tool, so that you make sure and you know what the 8th schedule and some of the languages that are there. So the question is, you have to identify which of the following languages were included initially in the constitution. So here you have to tell me which languages were part of the original constitution. And because we know some of the languages were added into the 8th schedule after amendments were made to it, right? So you have to leave out those languages in the answer. So we have Gujarati, Kashmiri, Konkani, Malayalam, Manipuri and Marathi. So in the initial constitution, we had 14 languages. Today we have 22 languages in the 8th schedule, right? So some of the languages which was added later on, like by 21st schedule, we had Sindhi language which was added later on, right? Then we had Konkani, Manipuri and Nepali. They were added through 71st amendment. And lastly, we had Dogo, Dogri, Maithili, Santhali. They were added through 92nd amendment, right? So keeping that information in our mind, your third option, that is Konkani, and your fifth option, that is Manipuri, they become wrong here, and so the answer here is your B answer, right? So again, any form of question can be made from this particular schedule. I told you this schedule is one of the favorites of UPSC. Like recently in EPFO also a question came. So just revise this topic. I think this is important. Next question is related to Article 311. Now this article is important because it deals with civil servants and their dismissal and removal kind of provisions are covered in this particular article. So the first statement here is that it puts certain restrictions on the absolute power of president or governor for dismissal, removal, reduction in rank of an officer. Second is that the protective safeguard given under Article 311 are applicable to both the civil servants and the defense personnel. And you have to identify which statement is correct here. So I think automatically when you read the second question, it says defense personnel also. So if you've had even one reading of the Constitution, there's no specific provisions that actually deals with defense personnel. In fact, if you go through in the constitutional, the fundamental rights area, some of the provisions of fundamental rights, like in the later, like 33, 34, 35, in these articles, some of the provisions have been kept out of the, defense area. So, I think automatically, if you're trying to link 311 with defense personals, then I think you should be able to capture that the statement is wrong. So, second statement is wrong. The first statement is that it puts restriction on the absolute power. Now, here the catch is that obviously there's this first provision says that no body which is subordinate to the one which appointed can remove a particular civil servant, right? So that means obviously the highest body like a president or a governor can issue that kind of ruling. But again, there's a second clause to it that they have to be given the right opportunity to speak against their charges or have a proper inquiry into it. So that is what is catching here. So there is no absolute power here. There is a certain set of rules and regulation that has to be followed, and only then they can be restricted or removed, or any kind of reduction in rank can happen. So the answer of this particular question is A. And again, do revise this section. I think the articles related to civil services is very less, so you can easily revise that section. Now let's move on to the last question of the day. Now this question is something different. Usually we talk about the creation of states and all those ideas, like how is a state created, the changing the name of a state, like which majority is related to it. So all, because they are the articles that are covered in your first few articles, right? But here we are talking about the creation of new districts. So the first statement here is that the power to create new district or alter or abolish existing districts rests only with the state government. Second, a state can create a district only by passing a law in the state assembly. So you have to identify which statement is incorrect. See, the creation of districts is something that obviously, even by common sense, you can link that districts are not created by the center. It's the power to create districts and all those things are actually allowed by the state government. So I think the statement one is pretty much clear. It's right. The districts can be created, the power to create districts lies with the state government. So the answer is actually B to this question, because second statement is wrong here. The second statement says that a state can create a district only by passing a law in the state assembly. Now again, I think you can apply that kind of Tigdam rule that the term only is here, so maybe the statement is wrong. But again, apply here a bit of a logic that every time you are trying to create a district, you have to pass a law in the state assembly. That can be a very huge task. So it's actually, the thing here is that the state government can either pass an executive order, or they can also pass a law in the state assembly. So that kind of flexibility is here present here. And usually what happens is many times the states actually follow the executive route by simply they issue a notification in the official gazette and a district is created. And basically the districts can be created because it allows better management. Administratively, it's better controlled. And again, center has no whatsoever rule to play with creation of districts. The only time maybe a district like a center's role might come is when you have to change the name of the district. right? Or the railway station that is near it. So there has to be certain NOC that needs to be signed from the central departments in that case. Otherwise, there is no involvement of the center here. So the answer for this question is B. Again, I think this was a new piece of information. Usually we've focused upon creation of states. So I thought let's bring it to a level lower, that is creation of districts, so that you can look into that piece of information as well. So that's it for today, guys. Hope you were able to learn something new in this short term video. And keep on practicing, keep on attempting more and more questions, keep on writing more mock answers. If you have any other doubts, you can reach us to us. We can provide you with mentorship, we can provide you with any kind of other necessities that you feel is required in UPSC examination preparation. So just let us know, you can reach to us, and all the best. Thank you.
Subscribe to our YouTube channel and press the bell icon on the YouTube app and never miss another update from Civil's Daily.